Good evening. You're watching CNN News 18. I'm Arunima. On today's edition of The Viewpoint, judiciary is in focus. We debate if the system to appoint judges needs a change, needs a relook. Union Law Minister is joining us to answer if the Collegium system of judges appointing judges is unconstitutional and hence a matter of concern, or is that the need of the moment to protect judicial independence?
The Collegium system is very opaque and people are not aware that how names are picked up. We felt that NJAC was a better option. Many judges, advocates, civil societies, everybody feels the same thing what I have been saying.
Independence of judiciary is one of the paramount virtues of the Constitution of India.
Leaving it exclusively to the domain of politicians would be worse, because in that event we will have all politically affiliated judges, which would completely jeopardize the fairness of functioning of Supreme Court and High Courts.
The debate over the best way to appoint judges has been on for a few years now. The NDA government, with support from other political parties, tried to settle the issue by bringing in the National Judicial Appointment Council, or the NJAC Act, in 2015. The Supreme Court struck it down, called it unconstitutional, and restored the Collegium system, where a team of 5 senior-most judges of Supreme Court, including the Chief Justice of India, or if it is the case of the High Court, then 3 most top judges, including the Chief Justice of the High Court, they were to decide on judicial appointments and transfers. Now, Law Minister Kiren Rijiju calls the system a matter of concern. What is the reason for this concern? What are the issues with the system of Collegium? Why is NJAC a better alternative? To answer those queries, joining me now on the show is our big news maker, Union Law Minister Kiren Rijiju himself. Sir, thank you so much for taking time out and speaking to the viewers of CNN News 18. Let me begin by asking you, you have raised concerns about the current system of judicial appointment. What exactly do you feel is the problem with the Collegium system? Why is that an issue? And what, according to you, is the problem of judicial appointment currently, because of which you think NJAC should be restored?
See, when it comes to National Judicial Appointment Commission, it was an act passed by the Parliament unanimously. All parties came together and passed this particular act in both houses of the Parliament. So, when all parties join, means it is a will, collective will of the nation. So, once a collective will of the nation has been brought together by all parties and passed through the Parliament, we were expecting that judiciary or the Supreme Court will respect the will of the people and will of the Parliament. But the Supreme Court, on its own wisdom, struck it down. So there is a sense, and as a law minister, I feel that Supreme Court has not agreed with the will of the people of India. Now the question is, if the NJAC was struck down, is the other practice or other mechanism which is in place better than what government had proposed? Definitely not. We felt that NJAC was a better option. But since the Parliament Act was struck down, we continued with the existing Collegium system in appointing the judges. Now, I referred to the practices in other countries where judges do not appoint the judges themselves. So, in India, now the Collegium in the High Court generates the name, sends it to Law Ministry, then Law Ministry processes it, sends it to Supreme Court Collegium. So, all this process takes lots of precious time out of the judges' precious time. Now, my understanding is that it is always better for the judges to devote themselves in delivering of justice. The primary duty of the judges are to decide on cases and provide the justice to the people as fast as possible. The senior judges, especially the members of Collegium, they are fully occupied in the process of appointment. It takes precious time, as well as the consulting judges. The consulting judges are, those who are relevant for the appointment of particular judges. So once the consulting judges is asked to give his preferences, comments and everything for the appointment of the judges, then it also, takes lots of their precious time. So my only limited point is that we must find out a mechanism to ensure that right people are appointed as judges, and the sitting judges should not devote much of their precious time in appointment of the judges. But we have no alternative right now, because Collegium system has given this role to the judges, and the Collegium system is very opaque, and people are not aware that how names are picked up, on what basis the names are generated. So these are opaque. So it is a concern, not only as a law minister I am saying it as my opinion, but it is a concern of everybody. It's many judges, advocates, civil societies, everybody feels the same thing what I have been saying it. So I am not criticizing the judges per se, but I am criticizing the existing system. So that's the very limited point which I had to say.
Right. So you're saying you're not criticizing the judges per se, but you have concerns about the system. But if you have to change that system, Mr. Law Minister, you will have to consult the judges. So have you begun your process of consulting the Chief Justice of India or the next Chief Justice of India, Justice Chandrachud? Have you spoken to him? Have you consulted the other senior members of the judiciary in Supreme Court? Has that process of consultation begun?
That I will tell when we get into some process of consultation. We keep discussing about many things, but I cannot divulge our informal or formal talks unless it comes into some shape. So, but the system which is prevalent is not actually the best system.
Right, so you're not revealing much, Mr. Rijiju, there, but he is, the law minister there is dropping that hint that something perhaps is in the pipeline, a way ahead, a way forward to look into the process of appointment of judges of the Supreme Court and High Court. Mr. Kiren Rijiju, thank you so much for taking time out and speaking to us, just to take that view forward, viewers, about who should really appoint the judges. There's been a lot of back and forth between the government and the judiciary. Let's break down both sides of the debate. Who is saying what? Who should appoint the judges? Those who are against the Collegium system, they are saying, and you heard the law minister say that the current system is opaque, it is not transparent. Why? Because the minutes of the Collegium meetings are kept secret. It's only the final decision which is now being made public. That's a recent change in the system. Judiciary against NJAC. Why? They feel that government undermines judicial independence. If you allow the executive to appoint judges, then that precious independence of the judiciary is compromised. Those against the Collegium say there's an empire within an empire in the Supreme Court. Basically, uncle judges picking their nephews and nieces, essentially meaning those that they prefer, only they get picked. Talent does not necessarily get priority. That's a critique against the Collegium system. Those who are against the NJAC say primacy has to remain with the Chief Justice of India. In the NJAC system, even though there is a veto power given, but there are also veto power given to the judiciary, but there are also other members in that NJAC committee to which there is a lot of apprehension too. System to blame for high judicial vacancies. That is what Kiren Rijiju also said, that precious time of judges is getting wasted in judicial appointment. Instead, they should focus on giving justice to people. Can't let politics influence judiciary is what those who are against the NJAC system are saying. So those are pros and cons in favor of the Collegium as well as the NJAC system. To debate that further, let me welcome all my senior panelists on the show. KTS Tulsi, a very senior member of the bar and also a member of parliament. So thank you so much for joining us. Aman Lekhi, former Additional Solicitor General, Senior Advocate. Justice B.A. Khan, former Chief Justice of Jammu and Kashmir High Court, and Senior Advocate Brijesh Kalappa. Thank you to all four of you for joining us here. Let me begin with the former Chief Justice who's on the show with us. Justice B.A. Khan, I don't know if you heard Kiren Rijiju. His points against the Collegium system, let me bring those to you one by one, and if you can share your views. Point number one, he says the Collegium system is opaque. Point number two, he says it is a matter of concern. Point number three, he says it takes a lot of time. And the sum total of all this is that it is not in sync with what the Constitution enshrined as far as appointment of judges are concerned. Your views, sir.
Well, Law Minister is entitled to his opinion, and he is partly correct. See, every system depends on the human resource, how that resource works. I am sure Law Minister must be conscious and aware of the context in which the Collegium came into being. Before that, we had a lot of hire and fire going on in the judiciary. Immediately after the emergency, there were supersessions, there were cherry pickings, there were politically committed people being brought to the courts. So it was in all that context that first we had three judgments of the Supreme Court. One was in S.P. Gupta's case, where the Supreme Court held that executive must have the primacy, which the Law Minister is just now advocating. Then we had second judge's case in which it was said that no, Chief Justice of India must have primacy, and one more judge along with him must be there. And then we had third in which this Collegium came into being. The expectation was that the five senior-most judges of the Supreme Court know better who is suited to be a judge of the Supreme Court or High Court, and that they have an element of integrity and honesty in selecting, and fairness also, because in judicial functioning, fairness and honesty are the two main qualifications. No, but as the time went on, as you have also hinted, that the Collegium system became, what do you say, its working left much to be desired. So there were complaints of nepotism, favoritism, as you were saying, uncle judges and so on and so forth. And it's true that there was no criteria, it was opaque, there was no transparency, you never knew who is being paid for what and what's his merit, and we have seen disastrous cases where people are being recruited to the High Court and the Supreme Court from areas where they don't know anything. Now, what I'm saying is that we have debated this issue for ages now. Earlier also, before the Judicial Commission Act was enacted, we debated this a lot, and we wanted a broad-based commission that time on the pattern of the South Africa, on the pattern of England, but that didn't happen. Now that Commission Act which was enacted, it didn't represent the will of the people. I disagree with the Law Minister on that point. Law Minister must know that in our Parliament there is only perhaps a 10% participation in legislative making. Now with that 10%, how can you say that a particular act of Parliament represents the will of the people?
So if you give me a moment, I want to bring in KTS Tulsi on specifically that point. Either allow me to complete. All right.
Or
I wanted to go to KTS Tulsi for just that particular point.
No, you please go to that. Let me complete this one point first.
All right.
Second is that with no or insignificant legislative participation by our people's representatives, you can't say it is the will of the people.
Right.
Number two, Supreme Court has a competence and jurisdiction to strike down a bad act of the Parliament.
All right.
So they have done it within their jurisdiction. But let me tell you, one may disagree with that judgment of the Supreme Court. One may also say that Supreme Court judgment involved a tussle of power sort of thing. Because the power was being taken away by the appointment of a judicial commission. Therefore, the Supreme Court struck it down on the ground that there was a threat to independence of judiciary by the
But I have to bring in Mr. Tulsi on that specific point, sir. KTS Tulsi, you actually were quoted when the Supreme Court, struck down NJAC. You were actually quoted to say that unelected people have decided to strike down something which elected people decided upon. They were representative of people in the parliament across, and this is what
Constitution.
That's what KTS Tulsi, sir. Mr. Khan, just give me a moment. KTS Tulsi. So now when Law Minister says that will of the nation was in favor of NJAC and Collegium does not represent will of the nation, how would you react to that?
Well, firstly, I would like to say that I am totally opposed to the last word being with the government in power. The executive cannot take a decision and have a last word, and I am also totally opposed to the judges appointing judges, because this is my opinion is formed on the basis of a few of the stalwarts who went into this, and the first one is that Justice Krishna Iyer, that there is no structure to hear the public in the process of selection, and he says that almost there is a universal chorus of comments that comment that the selections are unsatisfactory. This is MC Seetalwad as chairman of the 14th Law Commission of India. Then the appointment of judges is a disappointment, said Justice Krishna Iyer. The practice of appointing judges has painful effects on public welfare, said Ram Jethmalani. Now, there was a primacy argument being given by the Law Minister. The question is, we have not even begun the debate about how to do it. In the Constituent Assembly, Dr. B.R. Ambedkar warned against the system of judges selecting judges. To allow the Chief Justice to practically a veto upon the appointment of judges is really a transfer the authority of the Chief Justice, which we are not prepared to vest the authority in the Chief Justice, which we are not in a or the government of the day. Now the Constituent Assembly went into this and rejected the argument. On the primacy, we are only when the argument of primacy is raised, it only means that the executive is wanting to have the last word, which also is not
the ideal situation. Which not is the ideal situation.
Assembly.
But Aman Lekhi, having represented the government side of the story, at various courts, and now hearing what stalwarts are saying on this matter, would you also appreciate this concern that ultimately, if executive gets the larger say in judicial appointments, there could be a situation where we compromise the independence of the judiciary as the Constitution wanted?
Absolutely, but first I have a doctrinal objection to what the Law Minister has said, because I feel that the comment is rather loose and unbecoming of a Law Minister. The objection is, firstly, that it's not the proliferation number of people who support a bill, but the conformity of a bill with the norm which the Constitution sets out, which is the criteria of validity. Because you cannot simply say that because there is widespread consensus, because of the consensus, the law is valid if the law contravenes the norm, and what the norm is for the Supreme Court to decide. So the Law Minister is completely off the mark to the extent he says the Supreme Court should not have intervened because there was widespread consensus, because law is by nature anti-majoritarian and it is not a tool in the hand of majorities, firstly. Secondly, the admonition that as far as the judges are concerned, the judges should adjudicate and not be bothered with appointment is again conceptually flawed, because in the adjudicatory process is concerned with the matter of appointment too, and judges have got a vital stake in having the right appointees over there. So for the Law Minister to say, okay, you just do your job, leave the appointment to us, is assuming a role to the exclusion of the court, which is completely unwarranted and conceptually totally flawed. Thirdly, whatever the view may be, the question is the law today is what the Supreme Court has said. We may agree, we may disagree with it, but that is the law. And because we are government of laws, the government of India has to comply with the law and work within the law. When you work within the law, yes, I agree. Insofar as the National Judicial Commission judgment is concerned, is flawed. There is much to be said for Justice Selmeshwar's dissent in it. The question is, notwithstanding our personal views, the law is what the Supreme Court has said. And so the appointments are concerned, there has to be convergence of interests. And because both sides agree independence is not in dispute and competent people should be there, it's basically either preference or politics which is stumping capacity.
All right.
We have politics being played with the government, and we have preferences perhaps at the hand of the judges, and what is being compromised is capacity.
All right.
If there's committee of instrumentalities and convergence of interests where each of the stakeholders are concerned with having the right person as a judge,
right,
neither would there be a delay, nor would the method of appointment be important, because there will be convergence of interests as all the parties are concerned.
Okay.
The problem here is not the mechanism, because we are not in a perfect society. The problem here is working the mechanism. And as long as the intent is right, whether it's of the government or the court, I don't think we need to debate too much what the mechanism is. So I disagree completely with what the law minister has said, because I personally feel that just takes the carpet out of from beneath our feet insofar as law is concerned, and not something which would behove a government to actually say. The law is what the Supreme Court has said, and it is for us to actually work the law in terms of the principles which are well settled.
But Brijesh Kalappa, the man who gave us the collegium system, late Justice J.S. Verma, he too, towards the end of his life, started advocating that collegium system perhaps is not working the way it should, and the need of the hour is a judicial commission.
You see, Arunima, if you speak to both lawmakers and judges, both are ad idem that this system isn't working, right? But you must not forget that the collegium system has now been in existence for over 30 years. And of course, there are complaints, but it's still a system which works. And to some extent, there are difficulties, there are complaints regarding this system. But for 30 long years, it has worked in one manner or another. Of course, there are complaints. Any system will certainly have complaints. Now, the point is this, that both lawmakers and judges are alike, that the system must change. Now, my question is that if both the judges and the lawmakers feel that there has to be some change, and whether Article 124 and 217 are being operated, in terms of which the Constituent Assembly or the Constitution makers had created these articles, this question has to be answered after continuous deliberations. You asked a very important question of the law minister. You said, what is the consultation? Have you consulted the judges? This is where, there is something lacking. Why don't they talk to each other? Why don't the judges and the lawmakers talk to each other? There is a fundamental problem that each one feels, look, this is my domain and I am the owner of this domain, and therefore I have the right, complete right, to say anything on this subject. And this is insofar as how the lawmakers think, and that is continuously vetoed by the judiciary, whether in the second judge's case, the third judge's case, and further in the NJAC. So ultimately, unless these two, there are representatives from both of these segments, right, who sit, and there has to be a continuous process of consultation. And without consultation, we are not going to come to a system which is, good one way or another.
All right. So closing remarks then, Mr. Tulsi, I'll start with you. If there is, admission by all of you that yes, collegium system has problems and the NJAC system is not absolute either, what is the way forward? In 1 minute, sir, if you could summarize what according to you is the best way to move ahead with this issue of judicial appointment.
Well, you see, there has to be wider consultation. Here, the Act was struck down on the ground that there was not enough. There is no provision for consultation, and consultation in what is recorded in Section 1, Article 124. Right. Consultation is not concurrence. Okay. The Constitution has been rewritten. It has been rewritten that the last word should always be with the Chief Justice of India. Right. That was expressly disagreed to by Dr. Ambedkar. Right. All right. And how can we now attribute? We can't legislate by way of interpretation of a constitution.
Justice B.A. Khan. One of the charges is that the collegium system is opaque. So to solve that problem, is it to look for a fresh system or to make the current system more workable? Closing remarks in just a minute, sir.
No, it is certainly. Now, what is the way forward, as you asked Mr. Tulsi, is to have a broad-based selection forum. You have a selection forum even for appointment of a section officer. you have a criteria even for selecting an employee. How come that a judge of the Supreme Court and the High Court, there are no guidelines, there is no procedure in the judges, this Supreme Court judgment on National Appointments Commission case. It was agreed that there will be a memorandum of procedure which will be formulated both by the government and the judiciary in consultation with each other, which will provide a guideline, which will provide a criteria on the basis of which the merit of a candidate you are.
So broad-based consultation, sir. I'm really running out of time. I'm afraid I have to give the other panelists also a chance to give their closing remarks. Mr. Aman Lekhi, closing remarks, the way forward as you see it?
Way forward is healthy convention, not reliance only on legal provisions, and provides primacy to propriety, because as far as the stakeholders are concerned, each side knows who is to be appointed. It's either interference of politics or, for that matter, preferences of the individual concerned in the process which is initiating it. There will be no perfect system, but there has to be a perfect way of operating an imperfect system.
There should be a way to operate that system. Mr. Kalappa, would you agree? Rather than call the system opaque, a wastage of time, especially in your closing remarks, if you could dwell on that point that the Law Minister made, that judges should focus on justice delivery and not waste their time in judicial appointments.
No, not just that. I think insofar as judges are concerned, they have a host of other things to do. And one of them is, of course, judicial appointments. But importantly, I think both are constitutional functionaries. Both judges and lawmakers are constitutional functionaries. I think they have to sit across the table and work out the system on how the constitution should be worked. And if none of them can sit on a high horse and say, well, this domain is mine. I think both of them ought to get off their high horses and sit together and deliberate on this and come up with something which is workable, which helps and benefits all of us.
Right. I know this is a very complicated issue. To debate it in 20 minutes is very difficult, but appreciate all of you for taking time out and explaining to our viewers the nitty-gritties of this complex issue. KTS Tulsi there, Aman Lekhi, also former Justice of Jammu and Kashmir High Court, Justice B.A. Khan, as well as Brijesh Kalappa. Thank you so much for joining us. But that is not all. There are legal voices still coming in, weighing in on this issue that has been triggered by that exclusive interview, exclusive conversation that we had with Law Minister Kiren Rijiju, where he made a case that the current system of Collegium, where judges appoint judges, must change. He made a case of NJAC, saying that there is no other alternative that is available. What does a legal luminary, Kapil Sibal, have to say on this? We leave you with Kapil Sibal's comment on this big debate about Collegium versus NJAC.
Sir, how do you see the comments of the Law Minister have come in saying that the Collegium system is opaque in nature, it's not very transparent?
We have a lot of problems with the Collegium system, but from any standpoint it is somewhat better than the government having its way in appointing any judge they want to appoint. In fact, I have to say that this government has been trying to diminish the independence of all institutions in this country. And this is yet another statement made by the Law Minister to try and suggest that the power of appointment of all Supreme Court judges should be with the executive alone. I think we need to think of a hybrid system through which the process of appointment is more transparent. And the government's opinion is also taken into account. But to say that the NJAC was a better system than the present Collegium system is to say that, the executive wants to appoint the judges they want to appoint. That's unacceptable.